I've chosen a series of cases from 2020, and some of them are also from 2019. And I like to start, so it's the second slide. I like to start by reminding the requirements that must be satisfied to protect a registered community design. We mentioned that yesterday, both of us, David and I. The representation of the design must be clear, precise, and certain. Otherwise, it will be refused at the examination stage. This is one of the few things we do examine before registering a design. And the remaining, we do not examine before registering the design. And in order to attack those requirements, if you consider they have not been met, you have to attack the design in invalidity after it is registered. And the requirements mostly used is that the person attacking considered design re-registered is not new, or it does not have an individual character. In order to argue that, he must show that an earlier design has been disclosed prior to the registration of the attack design. And also we have interesting issues about technical function, because design registered and dictated solely by their technical function are not valid and can be, of course, attacked. So the first requirement about the representation of the design is examined already before registration, but the rest is not. So I've chosen, if you want to move the slide, I've chosen some cases in order to illustrate all these different important points in the life of the design. Representation, disclosure, individual character. We have more cases about lack of individual character than about lack of novelty, because novelty is assessed quite strictly, and the design must be identical, or at least almost identical. But I will have one case where the novelty was found. I will show you. Functionality and lesson from the ongoing Croc saga at the end of the presentation. So we can move on and start with representation of the design and move on again. Sorry. Yes, of course. I've prepared a new slide, but it does not matter on the presentation. I wanted to remind you, because you are in Southeast Asia, that at EU level, we have 4 different stages of taking decision. The decision of the first instance. So in case of designs, since I told you that mostly we do not register, we do not examine prior to registering the design, the first instance decision is at invalidity stage. So the design is attacked by a third party, and we take a decision based on the arguments of the invalidity applicant and the arguments of the design proprietor. If the party who loses is not happy with our decision, can appeal before the Board of Appeal. The Board of Appeal are also at EUIPO here in Spain. And then if the decision of the Board of Appeal is not satisfactory for one of the parties, it can appeal to the General Court in Luxembourg. And then it can appeal to the Court of Justice of the European Union only on point of law. So you see that we have a lot of case law. We have first instance case law, then Board of Appeal, General Court, Court of Justice. And the cases I will present you are taken from the Board of Appeals and one from the Court of Justice. So at the very top of the hierarchy. So about the representation of the design. On the slide, you have the contested registered community design that had 7 views, and it was a design of a potato chip, no? And it was attacked by a person who itself was attacked based on another design it had registered that was that had no individual character compared to this. And so, as a defense, he attacked the validity of the owner of the earlier design, saying that we should not have registered this design because it represented not a single product. You remember that yesterday David gave you examples of products of representation of designs that were refused because we could have thought that there were several products and it was not clear what was the design. Here, the case is that it is potato chips, but some of the representation, according to the applicant in invalidity, did not correspond to the same product. And in particular, if you want to move the slide for me, thanks. In particular, representation figure 4 and 6 were considered, argued by the applicant not to be in line with the other representation of these potato chips. And interestingly enough, he based his argument on the fact that the register community design was based on an earlier US patent designs under the priority on the US patent design. And some objections had been raised during the proceedings before the USPTO. And this argument, in fact, was rejected by us, by the invalidity decision, considering that, in fact, there was inadequacy between the graphic representation. It was the same product that was represented, and we did not buy the arguments about the US patent design. So we rejected the invalidity application. It's interesting because, in fact, we are not that strict that we are going to analyze and to with a loop all the different representation. If the global appearance makes sense and it looks like it is the same product, it will be fine. And then the invalidity applicant that lost at first instance appeal our decision before the Board of Appeal, and the Board of Appeal re-examined all the arguments and concluded that the design was correctly represented and could not be cancelled for lack of clarity and so on. So at the end, the one who attacked the design lost, and he also lost his later design in the parallel proceedings that he had with the applicant with the owner of the registered community design. The second case, also about representation, we can move on the slide, thank you, is very interesting because it has gone up to the Court of Justice. So we are talking about something that we examine how the design is represented before registering it. And here we have a case where the design, in fact, was never got a date of publication, because we say, it is said in the regulation that if the design is not well represented, it is deemed as not filed. So it did not have even a date of application. And why is it important for an applicant to have a date of application? Because as long as you have a date of application, you can claim priority of your design, even if your design never gets to be registered. So here, we understand that he lost a lot of money, the applicant of those top shot classes, to go up to the Court of Justice because he probably had a big interest in not losing his priority date. But for us, it's very interesting because it's not frequent that those cases about representation of designs go up to the court. So we have a confirmation by the court that what we are doing is correct in this sense. What you see on the screen is not the design application because, as I mentioned, it never received a filing date, meaning it was not deemed as being filed, and we cannot reproduce what has been filed by definition. But this was taken from the internet, okay? And you can see that you have several designs, you have several products. You have the bottles themselves, and you have those glasses, those plastic glasses that you put on top of the bottle in order to have a shot. And so the conclusion of all the saga, because it has taken several years, is a decision of the court of saying that the design must be identified from the beginning, otherwise confirming no filing date can be granted. Now we can move on to the disclosure of prior designs. Disclosure, we can move the slide, thank you. Disclosure of prior designs is an important issue when designs are attacked for lack of novelty or individual character. Because the first step for the person attacking the design in invalidity is to prove that an earlier design was disclosed. Establishing the date of disclosure of the earlier design can be very, very challenging, in fact. And because if you cannot establish that, your case will fail. Okay, we will not even assess the novelty and individual character because you were not able to prove that there was an earlier disclosure. So we can move to the next slide. There was an interesting case in 2020 about a boat, and so this case is from the Board of Appeals. And the issue was, you see that what I mentioned before, normally when the validity of a design is attacked based on lack of novelty or individual character, most of the time, we have to assess individual character because differences between the designs are sufficient to say that the design is new. In this case, what do you think? I mean, you see the two designs. I cannot hear you, of course, because we are not in the same room, but I would say quite obviously that it is the same design. And but prior to being able to say it's the same design, we have to be convinced that the earlier design has been disclosed properly and the evidence is correct. And in fact, at first instance, the invalidity division, if you want, we can move on to the next slide, rejected the invalidity applicant because of the bad quality of the evidence of disclosure. The applicant in invalidity had put hyperlinks to YouTube video and some screenshots, but it was not possible to make the link between the YouTube video and the screenshots. And so the invalidity application was rejected. And what happened is that before the Board of Appeals, they could complete the evidence that they brought at first instance. Normally, we do not accept new evidence at the appeal stage, but we accept evidence that comes in complement and that of the evidence that was brought in first instance. So the new evidence was not considered new within brackets, was considered as uh, uh, complementing what has been brought before. And at the end, the design was declared invalid for lack of novelty. I want to mention an interesting document. We will put the link into the presentation that we will publish about a common practice that has been agreed between EUIPO and national offices for the criteria for assessing disclosure of designs on the internet. And this document, which is very detailed, was adopted on 1st of April 2020. So it's a recent document which assesses all the different cases and what we ask and what we need, what is required in order to consider that the design has been disclosed on the internet. So I think it's interesting to mention that now. So we move on to the next case, which is about individual character. Individual character, a design has individual character if it produces an impression of overall dissimilarity compared with previous existing designs. We can move to the next slide. Here we can see two sofas, two inflatable sofas. I don't know if you are familiar with this type of products. They are quite new, thin, light, transportable, that you can fold. We had to compare the general shapes of those sofas. This is a case from the Board of Appeal. If you can move to the next slide. I don't know what is your opinion, but considering that the freedom of the design is wide, that the informed user is the general public, it was found at first instance that the overall impression was different. So that means that the attack design remained registered. And the Board of Appeal agreed with the first instance and considered that the appeal was not founded. So I hope that you can agree with that position. Then the next slide is about the technical function. I mentioned before that this is one of the interesting issues, not so frequent at invalidity stage, but when it happens, it worth mentioning the case. And here, because if a design is exclusively composed of features that have a technical function, it should not remain in the register. Once again, as I mentioned before, this is something that we examine only at the invalidity stage of the design. So in the next slide, you can see that we have a spray gun part. The contested RCD is the one on the left, and the earlier design is on the right. In fact, this is part of a paint nozzle. I don't know what you think about the contested design, but it looks pretty technical to me. The applicant invoked technical function and also invoked an earlier design, which is on the right, and attacked the contested design for lack of novelty, individual character. So in the next slide, you can see that the RCD was first declared invalid due to its lack of individual character, because we can choose the ground for invalidity that we want, that we consider is the best suited to the cases. And so at first instance, we chosen lack of individual character. That means you have to compare the two designs. The earlier design was from a patent, and in this case, it was pretty obvious that it had a technical function. So the losing party appealed our decision, and and lost the appeal because the register community design was still declared invalid, but the Board of Appeal changed the ground and decided to use the fact that the design lacked was exclusively composed of technical functions. So it's interesting because we don't have that many cases on technical function to see that several grounds can be invoked and technical functions can succeed, of course. Then to finish this presentation about recent developments, we can move to the next slide. And I thank you, the technicians, for their great help. And I thank the interpreters as well. I hope I do not speak too fast and too confusingly, and my French accent is not too trouble-making. So we finish this presentation with the Crocs saga. I like this saga because this is typically a product that had a big success on the market, as you probably all know it, due to its design. So Crocs is sold in 129 countries. It was brand of the year 2005 and 2007. We can move to the next slide. The story started in the years 2002. It was supposed to be a shoe for sailing, and then it had the big success that we all know. And Crocs filed first registered community design in 2004 with the 6 representation that you can see on screen. So you have line drawings, you have no color or material, you have no description, and they claim the priority of a US design patent. Then we can move to the next slide. In 2005, the Western Brands Incorporation of Colorado, which are the owner of the brands, they rebranded to Crocs in 2005, and in 2007 they were attacked. The design that I presented on the previous slide, 2004 design, was revoked, but still they continue to fight and to go up, you know, the revoked, first instance, Board of Appeal, General Court, Court of Justice. And at the end, you see July 2010, they appeal to the General Court, and then they lost, and the invalidation 2012 was withdrawn, and at the end the design was not revoked, and because they made a compromise probably, and so the design remained in the register. We move to the next slide to see that there is another series of things that happened to the same design, because in 2013, so the same 2004 design attacked Jiffy Diffusion, attacked the design. The design was first, invalidity was first rejected, but not on the merits, but because of what I mentioned before, bad evidence of disclosure of prior designs. It's very important to be able to build a solid file about disclosure. Then the Board of Appeal, probably the evidence was made better before the Board of Appeal, and the Board of Appeal find the design invalid. The General Court confirmed the Board of Appeal decision, and in 2020, the court went up to the Court of Justice, and the decision was closed after amicable settlements. So the design was not invalidated. So we can move to the next slide to see the lessons learned from this saga, that design registration is an incredibly effective weapon, of course, if filed soon enough, because you know that if you don't file soon enough, more than 1 year after the first disclosure of the design, you can be attacked because you have self-disclosed your design and you did not protect it within 1 year. You have 1 year to do that. So that was the fragility of the Crocs design of 2004. The shoe was first presented in 2002 in a sale fair. So the design was not strong because of that peculiarity, but still, when you have a registration, you have a certification of registration, and you are ready to fight in courts, you still have a title that you can use, and eventually, if your design is invalidated at the end, maybe you have built such a fame and that you can use the trademark system if you have enough evidence that at the end the design would be recognized as coming from a single origin. I don't know what you think about the Crocs design and whether yourself you would be able to identify the trade origin, but I think that's a very interesting example.